go ahead and introduce the next speaker, which is Stewart Rhodes of Oathkeepers. He's going to discuss the NDAA, and he's going to have more of a legal take on it. Of course, Mr. Rhodes is a graduate of Yale Law School, and I think that they're probably grabbing him outside. Is he not in the room right now?
All right.
Well, actually, I need a handout. Sorry about that. That's cut me off there. Okay, thanks, man. Hey, give me a 5-minute warning, okay? Hey, folks. NDAA of 2012 is the topic today, and this is actually something I've been talking about for, well, since 2004 at least. When I was a student at Yale Law School, this is post 9/11, and at that time, we had the Padilla case happening, an attention of a U.S. citizen, Jose Padilla. You had Yasser Hamdi, another American citizen, who was detained in indefinite detention by the military. And as a student at Yale Law School, I had like a kind of an Orwellian or Twilight Zone experience. I was the only student in my entire procedure class who said, you can't do this to an American citizen. You just can't do this. And I went and looked at the Constitution and I opened it up, and the first place that I found that applied directly to it was Article 3. This is what I read to the class. I said, hold on. It says Article 3, Section 2, the trial of all crimes except in cases of impeachment shall be by jury. And then the very next section says in Section 3, Article 3, Section 3, it defines a crime. It defines the crime of treason. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. Now, what was Jose Padilla accused of doing? Just that, making war against his own country or giving aid to the enemy. Same for Yasser Hamdi. So these are Americans accused of actions that constitute, they are the elements of the crime of treason. But what's the treason clause say you have to do with a person that's accused of these things? No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. Now, why did the founders insist on extra procedural protections and an extra evidentiary burden of 2 witnesses? Because they had seen in English history and in their own experience the abuse of the charge of treason. They knew the history of the Star Chamber in England, where people were tortured behind closed doors into confessing their crimes, and then that confession was used against them in front of a panel of hand-picked pals of the king. That's what they had seen. And in their own experience, many folks probably don't realize this, but in the lead up to the American Revolution, Parliament passed statutes. Part of the intolerable acts that they rebelled against was a denial of jury trial by statute. Removed the right to jury trial for certain offenses. Another statute was passed by Parliament, was one that allowed Americans to be taken across the seas and tried for treason in England instead of in the colonies in front of a jury of their peers. This was done by statute. This is the thing that leaped out at me when I was a student there at Yale Law School, is we were starting to go down the exact same path of denial of jury trial. And the other thing that they did is they subjected Americans accused of smuggling to trial by a court of admiralty, which is basically a military court in their day. And so they subverted and got around the ancient right to trial by jury in England, because they knew, of course, no notorious smuggler like John Hancock was going to be tried and convicted by a jury of his peers in Boston, because they were all patriots. They loved this guy. And so they knew they wouldn't be able to get him and punish him for what they considered to be crimes that the American people did not agree with, unless they deprived him of jury trial. And that is why when you go look at our Declaration of Independence, what's it say are among the causes of compelling them to separate, and among the causes compelling them to take up arms was denial of jury trial. It's listed right there. So I knew that history. And so when I saw them denying Americans jury trial, American citizens, who were accused of making war against their own country and aiding the enemy, I went straight to the Treason Clause and said, this is the answer right here. This is the constitutional mandate. I can't think of a clearer mandate for what you must do with a person accused of making war against his own country or aiding the enemy. He must be tried in before a jury of his own peers, and you have to have 2 witnesses or confession in open court. And why do they want confession in open court? To stop torture, to stop coerced confessions through torture. That was the point. And the Constitution itself, and then add to that the Bill of Rights, 4th, 5th, and 6th Amendments, what are those? Those are their attempts to stop what they had just gone through from happening again. They had just fought a desperate, bloody revolution against the strongest military on the face of the earth. Why? Not just because of taxation, that representation. That was nothing compared to the stripping away of the protections of the right to jury trial. For 800 years, Englishmen had struggled to institute that right. From the Magna Carta on, it was a long, hard struggle to make sure that people had. Who has the power to take away your life and liberty? Can the government do that? They claim the power to, but under our constitutional design, the government can never take away your life and liberty. Who can? Only your fellow citizens in a jury. Only you can sit in judgment over your fellow citizen and strip them of life and liberty. That ultimate power is in the hands of the people under the design of our Constitution. And even before the Constitution, under that ancient right of jury trial, which was one of the causes. Before there was a Constitution, before there was a Sixth Amendment, it was one of the causes of taking up arms because they considered it to be their birthright as Englishmen. And then they enshrined that birthright in the Constitution itself. And then they said, let's make double damn sure this is not violated, and that's the whole point of the Bill of Rights. Look at the preamble of the Bill of Rights. What's it say? If I can find it. The conventions of a number of the states, having at the time of their adopting the Constitution, expressed a desire, in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added. That's the whole point of the Bill of Rights, is to prevent misconstruction or abuse of its powers. And yet, what are they doing right now? They are misconstruing it, and they are abusing their powers. They're going way beyond the delegated powers in the Constitution. They're claiming a power of life and death over every one of you that is worse than anything King George ever claimed. And what are they claiming to be able to do? To treat you like a foreign enemy in wartime. Their argument is, and this began with the Lincoln administration, this is the first time it was ever argued, ever used. The argument is that in wartime, an American citizen can be treated exactly the same as a foreign enemy. Just like today, it'd be just like a goat herder in Iraq. What can be done to a goat herder in Iraq? He can be tried in Iraqi courts for some normal crime. But what if the U.S. military thinks he's one of the resistance and part of the insurgency? What do? Do they got to go to an Iraqi judge and get a warrant? They can apply the laws of war. And she's right. What can you do under the laws of war to an enemy? The first thing you can do is you can use military force. You can just kill them. If you capture them, if you bother to capture them, the second thing you can do is detain them for the duration of the conflict as a POW. Then, if you think they violated the laws of war, the third thing you can do to them is try them by military tribunal for violations of the laws of war. Those are the three things that every soldier, every sailor, airman, and marine should know can be done to a foreign enemy. What's your government claim the power to do to you? Just that. Use military force, military detention, military trial, and also extraordinary rendition, turning you over to some foreign country that can torture you in coerced confession. That began in 2001. It didn't start with the NDAA. The first application to this supposed power came out of the Bush administration, the modern application. Lincoln did it. It was ruled unconstitutional in 1866 by Ex parte Milligan by the Supreme Court, rightly so. Then after that, it was never claimed again, never tried to use again. Basically, the Supreme Court in 1866 put the genie back in the bottle. But then, in 1942, there were 8 German saboteurs came ashore, and one of them, his last name was Queren, or actually no, it was Hopt, but it's a case called Ex parte Queren. One of them claimed U.S. citizenship, and FDR, Franklin Roosevelt, said, I will not turn them over to a civilian court, even if they're a citizen. He issued an executive order claiming the authority to apply military jurisdiction and military trial by tribunal to anyone, including U.S. citizens, that he determined aided the enemy or made war against the United States. And so the Supreme Court in 1942 gave FDR what he wanted. Should it be a surprise? They ruled that the citizenship of this one soldier was irrelevant, that his citizenship as a U.S. citizen was irrelevant. What counted was what he was accused of. That if he's accused of violating the laws of war, he can be tried by military tribunal under the laws of war. That flipped the Milligan decision on its head, directly violated the treason clause, directly violated and wiped out the Bill of Rights. It was only done to one guy, and then people kind of forgot about that case. This is the same court that 2 years later, 1944, ruled it was constitutional to detain over 100,000 Americans of Japanese descent. Same court. Now, they were also, I would submit, being treated as a foreign enemy. Even though they were Americans, lawful residents, and U.S. citizens, they were treated exactly the same as you would later treat occupied Japan. Under military jurisdiction, they were rounded up and put in concentration camps. Treated the same as a foreign enemy population. So that's your precedent. Now, most people look back at the Korematsu decision, and even though it's still technically good law, you can ask the ACLU lawyer later on, they'll agree, it's been overturned in the court of public opinion. People realize it was driven by racial animus, it was a gross injustice and inequality, gross violation of rights. No one, I mean, hardly anybody will dispute that nowadays. Michelle Malkin seems to love indefinite detention of Japanese Americans, but nobody else. But the problem is that they focus on Korematsu as a justifiably, evil decision by the Supreme Court that should be given no respect. But yet, they give respect to the same court's ruling in Ex parte Queren, because it was about a German guy that claimed U.S. citizenship. There's not that obvious racial element to it. And so that decision, the Ex parte Queren decision, is the one that wound up laying around like a loaded gun to be used down the road by a willful president. And so that's the decision that President Bush and his lawyers cited back to in 1942. They could have cited back to Korematsu. It's still good law, but why didn't they? Because everyone knows it's a nonsense decision. But they referred back to Queren and said, oh, look, we can detain American citizens as well. And that's been the basis for all of the Bush doctrine since 9/11 for militarizing and bringing the laws of war home to America and applying it to all of us. From the very beginning, he claimed the authority to treat all of you exactly the same as a citizen of Germany in wartime, or Japan in wartime, or Iraq in wartime, or Afghanistan in wartime, under the laws of war. Now, that's the basis. Now, when this was challenged, unfortunately, when it wound its way up to the Hamdi case, when it wound its way up to the Supreme Court, the lawyers for the defense, for the defendant, did not, at least not to my knowledge, did not challenge Ex parte Queren as being an erroneous decision, one that should be overturned by the court, and going back to Milligan saying this is the right way to do it. You made a big mistake in 1942. Correct this. Is what they should have said. But they didn't. They hung their hat on separations of powers. They said, well, Congress hasn't authorized detention of U.S. citizens, and so under separations of powers doctrines, the president doesn't have this authority. Well, Bush said, well, I don't need your authorization. I have an independent power as commander-in-chief to do whatever I think is right to win the war on terrorism. This is the unitary executive idea or doctrine. That the president, once he's elected, is essentially an elected dictator. That he can decide what's war, who the enemy is, and what he must do to win it. He can do anything he wants. And your only check, according to John Yoo, one of his lawyers, is that, well, you just don't vote for him next time. But once you vote him in, that's what the Article 2 powers of the president are as commander-in-chief. That was their argument. Now, the opposition said, oh no, you got to have authorization by Congress, and Congress has not authorized this. And so they went to the Supreme Court, and the Supreme Court said, well, we don't need to reach that argument about whether or not the president has an inherent power to do this as commander-in-chief, because we find that Congress did authorize detention of U.S. citizens in the 2001 authorization for use of military force, which said the president has authorized to use military force against those nations, individuals, and groups that he determines had anything to do with 9/11 or aided those who had anything to do with 9/11. That was the authorization for use of military force. And the opponents said, well, that only authorizes military force. It doesn't mention detention. Well, the court said, well, hey, if you can use military force, then you can detain people too. And so the court ruled that Congress had given authorization. And so, the ACLU and all the other groups out there that were fighting on behalf of Hamdi, they were kind of dead in the water after that, because they didn't argue the Constitution. They only argued separations of powers. Yes, it's important, but it's not the treason clause. It's not the friggin' Sixth Amendment. That's what they should have been arguing. And to hell with Quirin. It's as much junk as Korematsu. It's as much junk as Plessy versus Ferguson, or Dred Scott, or the Schenck case from World War I, where they said speech that's tolerated in peacetime will not be tolerated so long as men fight, and some anti-war protester was put in prison. Where'd they get that? Is that somewhere in the First Amendment? They pulled it out of their ass. And done that throughout their history. So why give respect to that? That's the problem with lawyers. They give too much respect to court precedent that's wrong on its face. The Constitution is supreme law of the land, not some junky decision by a bunch of lawyers who are doing what they think is right in wartime. They tend to give, just like everybody else does, they tend to give away liberty and sacrifice it on the altar of security. The judges do it too. Don't give it respect. So here we are. Before the NDAA came along, we were already in a situation where you had the executive branch, and Obama picked up right where Bush left off, and he did one better. He said, well, hey, if I can detain people, I don't even got to bother with that. I'll just kill them. And he's killed 2 American citizens, ordered their military assassination. And in the challenge to that one, it came out that he has a secret list of other Americans he's going to kill. He claims the authority to just kill you. And don't think it's only going to be applied to Al-Awlaki or some other Muslim American overseas. What's the legal distinction between him and us? Nothing. There is no legal principle that says it can only be done to him, but not you. Once that door is open, it can be done to all of us. So, he is claiming, let's just recap this. Together, Bush and Obama, the executive branch, is claiming the authority to decide if any one of you is the enemy in the war on terror. And once they've so designated you on his say-so alone, he can just have you whacked. A predator drone strike, a sniper bullet, an ice pick in the back of the head, whatever. He can just kill you. Or, if he wants to, he can have you black bagged in the middle of the night and taken off to some military brig. Or, they claimed, they could do the same thing they've done to other people from other countries, send you off to Egypt or Syria or someplace else like that, where they have no civil rights, and they torture people. And they've done that to people all around the world. Grab them because they think they're part of the terrorist network, send them off to Egypt and have them tortured. It's been done to people, and it's been shown it's been done to innocent people. Well, there's no separation between them and you. They claim the exact same power. So what has the NDAA done? When you read it, all it really says is we affirm that back in 2001 in the AUMF that yes, we did authorize military detention. We did authorize military trial by tribunal. And we did authorize extraordinary rendition to any, it says to any foreign nation or any foreign entity. They could turn you over to some drug cartel, or to the UN, or to whoever else they want to. Like I said, to Syria. They're claiming the authority. This is what they're doing, and they say in the 2001 or 2012 NDAA, they did put boilerplate in there that says, well, nothing in here should be construed to change the powers of the president, or nothing in here should be construed to affect current law and authority. Well, the current law and authority already sucks. Right. The current law and authority, the claimed interpretation of the AUMF by both the executive branch and by the friggin' Supreme Court is that it authorizes military detention of U.S. citizens. They can apply military jurisdiction to you. And as I predicted back in 2004 by paper at Yale Law School, if they can detain you under the laws of war, what else can they do? They can just kill you. And I predicted that would be done, and it has been done now. So here's where we are. And where we are right now is a direct parallel to where the American people were in 1798 with the Alien Sedition Acts. You had a gross, on its face, violation of a very clear provision in the Constitution, the First Amendment. They were arresting and imprisoning newspaper editors and journalists for speaking out and speaking their mind and criticizing the government. A clear violation of free press, a clear violation of freedom of speech. But yet, it was a law passed by Congress, signed by the president, and do you think they could have gone to the courts and gotten any redress? The federal courts? They were packed with Federalists. The Federalist Party controlled all three branches of the government. There was no help to be had at the national level. All three branches were oath breakers. So what did they have to do? What was the answer? Go groveling to the courts, asking them to fix this when they'll laugh in your face and affirm it? The Supreme Court justice at the time, the Chief Justice, I think it was Justice Chase, writing circuit, was ordering juries that they had to convict under the Alien Sedition Act. They had to convict newspaper editors. He was directing them. So what kind of redress was there? None. So what did Madison say? What did Jefferson say in the Kentucky and Virginia resolutions? And Michael will talk about this even more. The answer is the states, and Madison said this in the Virginia Resolves, the states have not just a right, but a duty to nullify, to interpose, to stand up, to declare this null and void, and to protect the people against it. It's a duty. Just like when I raised my hand as a paratrooper and swore that oath to support and defend the Constitution, it's not just a right to refuse unlawful orders, it's a friggin' duty to do so. Duty bound. And we're at the same point now. We have the executive branch, the judiciary, and now Congress has jumped in and said, hell yes, we want this. Look at the vote in the Senate. Only 7 senators voted against this. What is your chance of a political solution anytime soon in the U.S. Senate? Now you should try. Part of what Madison and Jefferson did, they did a 2-part strategy. One is to nullify and call for nullification. The second one is using that condemnation, that indication of how bad things were. They were able to sweep the Federalists out of office, what was called the Revolution of 1800. Clean them out. But I would submit to you that the population back then, who had just fought a revolution, was much more aware of their rights, much more aware of tyranny. They had felt it, they had fought against it, and they were much more likely to do the right thing and clean them all out. We now live in this disease of a 2-party system where everyone's afraid. They want to just vote for the lesser of 2 evils out of fear of the other party, and the political powers that be understand they can manipulate that. And so I think our chances of a political recourse like that are slim and none, in the short term at least. So what's the answer? Well, I started Oath Keepers because of this. This is the number 1 reason. Katrina was number 2, but this was number 1. I realized that if I'm going to buy enough time for us to be able to fix this, we're on a collision course right now with either becoming Nazi Germany or fighting another revolution. Take your pick. That's where we are. We're at a crossroads. It's either 1934 Germany or 1774 America. Take your pick. That's where we are. And even if you were to sweep all the bums out of Congress, that still leaves that Hamdi decision sitting there. Still leaves that Quirin decision sitting there. Or the Fourth Circuit decision in Padilla is even worse. So what they've done is they've done almost irreparable harm to our Constitution. You'd have to have a whole new Supreme Court that overturned all that garbage and reaffirmed the Bill of Rights and reaffirmed the Treason Clause. But until you can do that, your rights are now at the mercy of Congress. It's a matter of legislation. They take what was supposed to be the highest law of the land and knock it down to the level of simple bills in Congress. Like the NDAA. While most of us weren't paying attention to it, they snuck it into an appropriations bill for the military, which everyone's afraid to vote against. No one wants to vote against supporting the troops. I had Denny Rayford, my congressman in Montana. I confronted him after a public speech, and he accused me of not supporting the troops. He said, you just don't support the troops. Shame on you. That's what he told me. He didn't know who I was, I guess. I didn't wear a name badge. But I'm going to make sure that he regrets that. I'm going to make sure that I see that. One thing I can do is I can make sure that he never sits in public office again. I will make that my personal mission in Montana. You probably heard the story of the starfish, right? The guy's walking along the beach and he's throwing starfish back in the water, and someone says, "Why are you doing that? There's just so many of them. You cannot possibly save them all." He says, "Well, it matters to this one." Well, same goes with Denny Rayford. I can't get rid of all the bums in Congress, but I can fix this one right here. I can chuck him in the trash. That's what I'm going to do. So, what do? We have to, and I'm sure Michael will elaborate on this, we must nullify as individuals. We must nullify, especially in the military, individual soldiers, sailors, Air Force, Marines. They got to nullify and refuse to do any of this to their fellow citizens. As units, I hope the whole freaking Marine Corps refuses to do this. And that's why we're doing a big base tour throughout the country and talking directly to them about the NDAA. Because if they don't, and here's the message to the troops, if you don't stand down and refuse to do this, to buy us time to clean the bums out and fix this, if you don't do that, we will not become Nazi Germany. We will not go quietly into the night. It will not go down like that. And how do I know that? Because I talk to veterans all across America. And a lot of them have told me, these are guys who don't even know each other, come out of the blue, from North Carolina to Northern California and from Montana, and they all say the same damn thing. They say, you know what? The first time they black bag another veteran in this country, I'm not waiting for them to come to my door. It's on. That's what they told me. I'm going to go after them. What do they mean by that? They don't mean their fellow soldiers. They mean the guys who are giving the orders, the guys who voted for this crap. That's who they mean. Now, I don't want to see that happen. But the message to the military is going to be, and the legislatures also, I'm handing around to you something I submitted to the Kansas legislature last week that said, basically that message, look guys, you have got to stand up. If the states don't stand up and interpose and protect the people, what is our recourse after that? If the military, God forbid, starts to obey these orders and local cops assist, the veterans of this country will fight. They will. They will feel compelled to. They'll have no choice. Just like their forefathers had no choice. Where's my timer? Okay. So I'm going to read you, just to recap on this a little bit, is to read you some of the causes for taking up arms in our Declaration of Independence. He has effected to render the military independent of and superior to the civil power. What was that? That was martial law in Boston by General Gage. That was the subjection of them to admiralty courts. It was martial law. This does the same thing. This claims that the laws of war trump the Bill of Rights and can be overlaid over our Constitution and swallow it up. Next one, he has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretend legislation. This is the same. Obama has combined with others in Congress, John McCain, Carl Levin, Lindsey Graham, and the rest of those oath breakers, to subject us to a jurisdiction foreign to our Constitution. What's more foreign to our Constitution than the international laws of war? Where do you see in the Constitution where it says Congress has the power to declare war upon the American people? or to subject them to the laws of war as if we were an enemy population. It's not there. But they're doing the same dang thing now. For depriving us, in many cases, of the benefit of trial by jury. And that's exactly what this does. Nullifies the entire Bill of Rights, sets aside Article 3, and subject us to trial by tribunal rather than jury trial. For transporting us beyond the seas to be tried for pretend offenses. And under the NDAA of 2012, where can you be taken? Off to Guantanamo. And when you get there, who will determine whether or not they made a mistake? A civilian jury, a grand jury? A military judge will determine your status. This is the problem with the Hamdi decision. At the time it came down in 2004, I was like pulling my hair, I was left in my hair, pulling it out, going, I can't believe this. All of these civil rights organizations are claiming this is some great victory for the Constitution. Because Bush didn't get everything he wanted. He claimed that the courts had no business even reviewing the case. He could do as he pleased. He didn't get that. The court said, well, the powers of the presidency in wartime are not unlimited. And they made a bunch of boilerplate language about the importance of checks on executive privilege. But then they ruled that nothing in the Constitution bars the United States from detaining one of its own citizens as an enemy combatant. But they said, oh, he gets a right to a lawyer and a right to challenge his designation. But how's that going to work? Well, the court said, we'll have to figure it out as we go, but it may be satisfied by a military tribunal. It said a military tribunal may satisfy the requirement for an impartial review. Forget about juries, even forget about a civilian judge, even though that would be unconstitutional too. The jury is supposed to be the one deciding, not a judge. But hey, a military tribunal, some judge down in Guantanamo. What does Section 1022 of the NDAA say? It'll be a military judge who makes determinations of status. So they've answered all the questions that were left over after the Hamdi decision. Not only does Congress authorize detention, that's all the Hamdi decision said, they've gone one step further, authorized military trial, and they've said that any determination of your status will be determined by a military judge. That is who will hear your challenge, such as it will be, to your designation. So once the president designates you, he could just kill you, but if you're lucky enough that he doesn't kill you and they detain you, then he can say, oh, you made a mistake. I'm not Al-Qaeda. Yes, you are. The president said so. No, I'm not. Okay, well, tell it to the military judge. What do you think your odds are of convincing the military judge you're not Al-Qaeda? You want a good indication of what kind of trial you're going to get? Take a good look at what just happened to Marine Sergeant Gary Stein. What kind of a trial did he get? I was there. I was at his hearing. All day until 11 o'clock at night.
You were representing him.
I was representing him. Part of his team. Minor part of his team, doing what I could. My main job was to secure witnesses, prepare witnesses. We were not allowed to have one single witness in his court. We had them all lined up. Retired majors, a retired brigadier general was there to testify for him. They did not allow him to testify. It was a complete sham from the very beginning. And we gave them stacks of law review articles and court cases to review. And the other side gave them stacks of stuff to review too. You know how long they deliberated? 40 minutes. Did they read all of that in 40 minutes? We gave them written testimony because they would not let the former judge advocate general, the guy who was a JAG all his career, brigadier general, they would not let him testify. They wouldn't let a retired major in Oath Keepers come testify. We had a bunch of people lined up. They would not let them testify. We submitted written statements from senior NCOs, sergeant majors, retired generals, retired senior officers. All of those were given to them. There's no way they read all that in 40 minutes. They walked in there knowing what their job was. What was their job? To make an example out of him and run him out of the Marine Corps. What's going to be the job of the military judge at Guantanamo when they got you sitting there, or wherever they have you held, whatever brig you're at? What do you think? It's just the Star Chamber all over again. Same kind of nonsense that happened in English history that our forefathers fought against. For taking away our charters, abolishing our most valuable laws, and altering fundamentally the form of our government. They've done the same thing here, taking away our Constitution, away our Bill of Rights, and altering our form of government rather than civilian authority being paramount in civilian courts and civilian juries. Now it's military law. So for suspending our own legislatures and declaring themselves invested with power to legislate for us in all cases whatsoever. And of course, Congress has claimed that too. Where do they get that power? What's Pelosi say? Are you serious? They presume it. And the last thing I want to point out, the last charge against the king that compelled revolution, compelled taking up arms, they said, and compelled separation. He has abdicated government here by declaring us out of his protection and waging war against us. What do they mean by that? They meant that the king had given up any right to govern over them. By his own actions, he had abdicated his own throne. He was no longer a just king under the English system, under the English Constitution. He had violated everything. So he had destroyed the English Constitution. He destroyed the compact with the people and abdicated his right to rule by waging war against them. It's a two-way street, they were telling him. You can't just treat us like a foreign enemy without us treating you like a foreign enemy. And so they said, hey, we are absolved any obedience to you. We owe you no more allegiance because you have stepped across the line and abdicated your right to rule over us by declaring us out of your protection and waging war against us. What's happening right now? What's the treason clause say treason is? What is it? It's waging war against the United States. We're aiding its enemies. What do you call it when an entity claims the authority to use military force to kill you, detain you, try you, or turn you over to some pal of theirs to torture you? What is that? Treason. It's war. They're claiming the authority. They're claiming that you cannot be designated the enemy in wartime. In their heads, it's a one-way range. It's war going this way, from them out to you. Whenever they want to, they can just use selective warfare on any of us. What they don't realize is what they're opening is a two-way range. It's not going down to a local shooting range where it goes only one way. Warfare goes both ways. If they're going to treat us like an enemy in wartime, how shall we treat them? The American people will come to the point where they'll be compelled to treat them how they're being treated, just like the king. And so what they've done to us is what they're doing right now, is declaring us outside the protection of our Constitution, outside the protection of our Bill of Rights, and waging war against us. You might think that's boilerplate and hyperbole, but no, this is the principle. Long before you feel the effects, you should stand up against the principle. They claimed authority, they claimed power. Long before, people rounded up dissidents, people he didn't like because of their race. Long before he did that, he claimed the power to do that. And so don't wait for the full effect. Our founding generation did not wait to feel the full effect of the claimed authority of Parliament and the King. They rebelled against the principles. We have to do the same. But the point will come where we're on the cusp right now of this national government, Congress, the judiciary, the executive branch, of destroying the Constitution so bad that they will have wiped out the very thing that gives them their offices. If they wipe out the Constitution, do they hold any more office at all? They become nothing but naked men and women with no power whatsoever. And so, like I said, it's a two-way street. They cannot destroy the Constitution without destroying themselves. And that'll be the other message to the military, is that you need to be thinking to yourselves, what do you do when the national government goes so rogue that they've destroyed the very thing that created them? What is the answer? And I think the answer is the same answer as where should be the focus of resistance? It's in the states. Nullification truly is the middle ground, as Thomas Woods always points out. It is the middle ground, because that's what we hope to do to stop things from deteriorating to the point where the Constitution is destroyed. But what if the Constitution is destroyed? Then what? Do you live under some unconstitutional, illegitimate, tyrannical, foreign entity, a military dictatorship? Do you submit to that? No, you don't. My answer, and this is what I'll tell the military all across this country, is that you should be thinking in your head that when they destroy the Constitution so bad, they've destroyed the national government, you default back to being states again. And that's where your loyalty should lay. The military, we do not want the military to take powers into their own hands. We do not want to see a military coup in this country or a military dictatorship. That's going from the frying pan into the fire. So the answer is, as always, they should be subservient to the civil governments. That would be the states. That'd be my answer. But that's the worst case scenario. But that's where we are, folks. If you, every one of you, does not stand up right now and be a leader in your community, get your sheriff, your county, and your state to nullify against this and start standing up, then it'll fall. Then it'll be who else will be there to stop it? Only the military. And if they don't stop it, then it'll fall to us veterans. If you don't want to see that happen here, if you don't want to see another American Revolution or a bloody Civil War, that's what's coming if they don't stop this crap. If you don't want to see that, then you got to get up off your chairs right now and help us to nullify at every level. God bless America.